Hello. Just before I start, thank you very much for having us here tonight. My name is Hanna, and I am a NIMBY. I'm a NIMBY, and I'm proud of it. Because NIMBYs are people who care. They care about their families, they care about their neighbors, and they care about their communities. About 2 years ago, my wife Lorette and I discovered that our community, our neighbors, and our family were being threatened by the development of industrial electricity generation within mere meters of our home. We spent a great deal of time researching the pros and cons of industrial wind and became justifiably alarmed. In August 2008, we joined APEC, the Alliance to Protect Prince Edward County, hoping to help take these concerns to our government, assuming they would listen to reason and respond. Not only did they refuse to listen, they dismissed all opposing views and engaged in a juvenile performance of schoolyard bullying and name-calling, labeling legitimately concerned citizens with their favorite term, NIMBY. Our very own Premier and his closest associates engaged in these puerile tactics. The best they could do was shout, NIMBY. Well, I'm a NIMBY, and I'm proud of it. Because NIMBYs are people who care. We care about our families, we care about our neighbors, we care about our communities, we care about the two people who spoke just before me. We care about all the other victims in this province. And I know you do too. Our own local municipal councillors were completely disinterested in the issues. Our provincial elected representatives were too busy bullying and name-calling to listen. So on Thanksgiving weekend 2008, my good friend and neighbor Henry Garand and I began visiting every home on Big Island where we live. Now, for those, probably just about everyone in this room, Big Island is actually a little tiny island that lies in the Bay of Quinte, just off the north shore of Prince Edward County. It's about 3,000 meters wide at the widest point and 7,000 meters long. Plans were afoot as a part of Sky Power's Byron Wind Farm development to place between 15 and 20 1.5 megawatt industrial wind turbines on Big Island. In the first phase. So on Thanksgiving weekend, Henry and I, armed with our petition, began knocking on doors. And over the next 3 weeks, the only good thing to come out of this whole darn trek, we met practically every one of our neighbors. And we talked with them. And over 110 of them, that's over 80%, signed the petition. We presented the petition to Prince Edward County in November at the same council meeting, by the way, that Dr. McMurtry presented his original request for epidemiological studies. A motion requesting those studies was passed by PEC Council, as Dr. McMurtry told you, and now over 60 communities have followed suit with similar motions. By early January 2009, we could see there was absolutely no interest at Queen's Park in anything we were saying. The Green Energy Act was on the horizon, and it clearly was just a matter of time before they would legislate us out of the picture and turn the entire province over to their friends, multinational developers. APEC sought legal advice at that time from renowned Canadian environmental lawyer Eric Gillespie, starting in about September of 2008. And Eric continued to advise APEC through the fall. as it became increasingly apparent to us that the legal challenge was going to be our best option. By late January '09, my wife Brett and I began consulting with Eric personally as well. It was clear to us the only way we were going to be heard by a government which had lost all contact with and concern for a rapidly increasing number of citizens who had grave concerns about IWTs would be in the courts. Indeed, it appeared to me the only way we could stop them from destroying our homes and rendering them unsafe for habitation, from indelibly industrializing much of rural Ontario, from eroding the value of many families' most significant asset, the only way to make them listen to reason would be in the court. Now let me be clear, our greatest concerns were focused on the health and well-being of our family and our neighbors. And the little birds and animals too. We kind of like them. But this government dismissed our fears which were based on the very real and terrible experiences of other Ontario residents suffering the effects of industrial wind turbines. They dismissed our fears with political obfuscation, outrageous claims that we were trying to prevent them from closing coal-fired plants. Every time we raised the red flag at the harm being done by industrial wind turbines, they turned to coal. This government will never close a coal plant as the result of building wind turbines. It simply cannot happen. McGuinty and his supporters point to Germany as the world's great model of industrial wind development. But they conveniently leave out the fact that Germany has not yet closed one coal generator, despite building tens of thousands of industrial wind turbines. In fact, they continue to construct new coal generators at an alarming rate. So, with Eric Gillespie's able assistance, we initiated a legal strategy to defend our rights and to protect people from this harmful industrial development. We were originally ready to move in March 2009, but we delayed action until the Green Energy Act was announced, debated, fine-tuned, and eventually passed into law. Just as a little aside, we didn't want to hit or try to hit a moving target. In the end, this act legislated us out of the process. Ignoring, dismissing, and bullying had been a prelude to the real thing, being disqualified by legislation from any input into decisions which threaten our health and well-being and the destruction of our homes and properties. The Green Energy Act and associated regulations enshrined in law, however, the very policies that we would challenge. Seeing that the government had ignored citizens and experts alike in their pleas for epidemiological studies to determine the safe and appropriate setbacks, in favor of allowing a continuing assault on rural residents of this province, we were ready to move. The Green Energy Act was finally passed into law at the end of September '09, and on October 19th at Queen's Park, we announced that under my name, on behalf of all Ontarians threatened by this legislation, we had filed an application for judicial review of 4 sections of the Green Energy Act. These are the sections that regulate the siting of wind turbines and associated equipment, such as transformers. The action is based on a couple of simple precepts. The precautionary principle, which simply says, when considering development, if there is any degree of scientific uncertainty that the development will cause harm to humans, animals, or the environment, that precaution shall prevail. My mother used to say it, check the water before you dive, look both ways before you cross the street, and she had a lot of them. They all made sense. Do the research first. One must prove that such harm does not exist before proceeding. The onus is on the developer to prove harm will not result. It is not on the potential victim to prove that it will. Secondly, the Ministry of the Environment has developed a statement of environmental values which governs their actions. One of those values states they will respect the precautionary principle in decision making. 1 + 1 is 2. It's our position that there is significant scientific uncertainty surrounding the health threats associated with industrial wind turbines. Furthermore, we assert that the Ministry of the Environment has clearly not respected the precautionary principle as required by their own statement of environmental values when determining the setbacks that are set out in the Green Energy Act. Application, as I said, was filed October 19th. In January 2010, Counsel for the Ministry of the Attorney General confirmed that they would act on behalf of the government in this action. And CanWIA, the Canadian Wind Energy Association, was kept in the loop, although at that time they had taken no action to become officially involved in this case. We submitted evidence to the other side for review early in March in the form of an affidavit from Dr. Robert McMurtry. And we subsequently received responding evidence from the Ministry of the Attorney General, and at the end of March, and then cross-examination of witnesses was scheduled for May of 2010. At that time, the court set a hearing date for us of September 30th. It's very interesting and very, very important for everyone to realize that the court really does seem to recognize the importance of this case to both sides. And it appears to us that they are working hard to avoid substantial delays.